afternoon, everyone. Thank you for joining us for today's online talk. We will be starting shortly, so stay tuned. For those of you who are already here, we thank you for your patience. While waiting, we would like to share with you from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationship with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Understanding Your Options Under Shariah Estate Planning, Wasiat and Hibah. My name is Zoe. I'm a pupil in Chambers with Marvin Kwai and Associates, and I will be your moderators for today's sessions. Before we start today's talks, let me introduce the firms and explain the work that we do. Marvin Kwai and Associates is a mid-sized firm that was founded in 1985 by Datuk Marvin Kwai. Our teams today comprises 33 lawyers and 31 support staff. Datuk Ma himself is currently a consultant with the firm, following his retirement from the Court of Appeal bench in 2015. Today, the firm continues its traditions of working primarily with SMEs, family business, and individuals. We are a full-service law firm with a corporate department, a dispute resolutions department including litigation and arbitrations, a dedicated employment industrial relations teams, as well as a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, as seen here, which are supported by great talents from both our corporate and dispute resolutions teams. Today's talk is part of our MWKA online talk series. To get a bit of knowledge, we have been organizing monthly lunch talk at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute any legal advice. In the event that you require specific legal advice for any matter, please contact us for the complimentary legal consultations. Details will be given at the end of this talk. We have two speakers for today. Allow me to introduce them. We have Ms. Anis Mohamad Sohaimi, which is our senior associate in our firm. Second, we have Ms. Mira, who is an associate in our firm as well. Points for today are key differences between Wasiat and Hibah. Second, when and how to use a Wasiat or Hibah. Thirdly, planning for non-Muslim relative, blended families, adopted children or foreign assets. And lastly, avoiding common pitfalls. Anis will speak on the first and second point, and Mira will continue the third and last point. We will then conclude the talk at the end with Q&A sessions where we will address any questions you may have. So if you do have any questions, please type in the chat box. We will address them at the end of the talk. Now, allow me to pass the floor to Annie to begin our talk for today.
Thanks, Zoe, for the introduction. Good afternoon, everyone, and thank you once again for joining us today. So the first top point is key differences between Wasiat and Hibah. As you may be aware, there are actually quite a lot of concepts and documents involved in estate planning. But before we go into these specific two, since this talk will be focused on Wasiat and Hibah, I wanted us to take a step back and look at an overview of the Shariah estate planning process. So I wanted to share this diagram to show that a lot of us often associate Shariah estate planning with things that happen after death. So that's where the wills come in, the wasiat comes in, and we hear this concept of Fara'id as well. But Shariah estate planning goes beyond preparing for death, obviously. A lot of it also has to do with all the steps we take before the death. So obviously death occurs, and that's obviously a triggering point, but there's actually a lot of things we can consider before that. And that's where Hibah comes into the picture. And I wanted to illustrate in this diagram how Hibah is something that you consider before death, and Wasiat will come after death. And so where you are in terms of planning your estate planning, obviously you want to be at the front of it and make sure that any issues that could occur, you've already assessed and addressed before the death of anyone, of yourself or anyone you love. And so to do that, you will hear terms such as Hibah, which can be referred to as an inter vivos gift, which we'll look into detail later. But there's also this concept of a trust deed and a power of attorney. So I wanted to give you a brief overview of those first before we go into. So these are the key estate planning instruments. We'll look at the first two in detail, Hibah and Wasiat. And let me just take you through the other aspects which are also involved. So Fara'id is Islamic law of inheritance or succession, and it refers to the system as a whole, actually. There's also, I think, sometimes people misconceive that Fara'id is the only thing that Muslims need, and then they disregard Wasiat or Hibah. So that's obviously not true. You can see it is part of the estate planning process, and it serves the purpose of distributing the estate among heirs according to the fixed portions under Sharia, and it's effective upon death. So there's nothing you can do to prepare after death, before death, to change the Fara'id, the people entitled to it, unless you talk about marriage and children and all that. And then there's the trust deed, which is a legal instrument where assets are managed by a trustee on behalf of a beneficiary. So this is usually used by people who have a lot of assets in terms of corporate assets. So they may have like companies, they may have trust corporations, they may have like trust properties. And so what they will do is they'll put properties in the name of someone else, in the name of the trustee. And what this serves is a trust deed will survive your death, because although the trust deed is executed during your lifetime, the terms of the trust deed and the assets and how it's managed and all that, it follows the trust deed. And this instrument and the appointment of the trustee can survive your death. So that's where you hear this is utilized for things like you hear like trust fund babies and all that. So this is the instrument that is often used by those people who have such assets. And another key planning instrument is power of attorney. So it authorizes someone to act on your behalf while you're still alive. And it usually is used to manage affairs during incapacity. Usually it's either illness, but it can also be used, for example, of people who have relatives overseas. So if they cannot go to transfer property at the land office physically, they can appoint an attorney to do that for them. And I just wanted to highlight here how it's important to understand how all of this can serve your estate planning process, because I'll give you an example of someone who wanted to plan from A to Z to the extent that they've utilized a wasiat, a trust deed, and a power of attorney. I can give you one example that we had to advise on once. It was an elderly client, and he was concerned because he had relatives they have a history of dementia. And although we always want like a long-lasting life, he realized that a lot of the relatives had a long-lasting life, alhamdulillah, but they were incapacitated due to illness, dementia. So it became a factor that affected their estate planning process. So he wanted to make sure that in his estate planning process, his family would not be burdened by this situation. So what he did was he planned a power of attorney to take effect in the event of his incapacity. And before that, and actually simultaneously, he executed a trust deed. So he carved out all the assets that he believed would be better managed by appointed persons that he identified. So he put it all under a trust deed. And he also executed a wasiat for properties that he still wants to use during his lifetime, but after he's gone, he may want to pass it on to his beneficiaries. So you can see how planning can consist of many documents, and sometimes it doesn't have to be one or the other. It can be used to support one another. And obviously what is used and how it is used depends on the instrument involved, and obviously the purpose and the intention that you want affected upon your. So after going through that, let's dive into the main top points today, which is the wasiat. First of all, So what is a wasiat? In simple terms, it is a Muslim will, and it refers to a document which contains a person's intentions on the distribution of his or her assets at death. So practically that is the understanding. But this definition is reflected in the Muslim will's Selangor enactment, but you'll note that it defines a wasiat as a promise, an ikrar, made by a person during his lifetime with respect to his property or benefit thereof to be carried out for the purposes of charity or any purposes permissible by Islamic law. So it reflects that practical understanding, but it further defines ikrar to mean an admission made by a person in writing or orally or by gesture, stating that it is under an obligation to another person in respect of some right. So from this definition, you can actually see that there are the basic pillars of a will, which is the testator, the person executing the will, the beneficiary, the person who will bequest the property, who receives the right or benefit, and the subject matter. So based on the previous definition, a wasiat can actually be made orally, in writing, or by gesture. So this is where it distinguishes itself from non-Muslim will, because non-Muslim wills have to be made in writing. So for a Muslim, it can be made orally or in writing, and it can also be by gesture. But of course, gesture is usually limited to those who cannot read or write. Special circumstances. And in each of these cases, it must be made before two witnesses who are competent to be accepted as witnesses according to Islamic law. So this is a standard trustworthy adult Muslims of sound mind, and we usually encourage that it's people who have all their five senses intact. So obviously they can see, they're not deaf, and they have all their capable senses. And if you choose to do a wasiat, which we encourage obviously to have something written down, a written will may be made in accordance with the form set out in the second schedule to the enactment. So it is a reference that you can follow, but it's not something that you need to follow to the letter. And for the conditions of a testator, they must be 18 years old, not of sound mind, and acting on his free will without coercion, and a person who is not prohibited from administering his property. So for example, it would be a person underage, they wouldn't be able to do that. The next pillar for the wasiat is the beneficiary and the subject matter, the next two pillars, sorry. So for a beneficiary in a wasiat, it must be to non-legal heirs. So it will be all those that are not entitled to faraid. So this would mean it cannot include your spouse, your parents, your children, and if applicable, your siblings. In terms of who are, that would be a separate topic under faraid, but this is just the primary heirs that I'm highlighting. So the primary heirs, they're not entitled to inherit under the wasiat, but they would be entitled to inherit under faraid. And the beneficiary must be known and identified, and it must be someone who's competent to own the property. So if you've read it in other jurisdictions, some jurisdictions recognize properties bequested to dogs or pets. So obviously in Malaysia, this would not be possible, because obviously it has to be someone who's competent to own the property, and in accordance to our laws, we don't recognize dogs as owners of properties, but we do recognize them. That's in terms of the conditions for the beneficiary. In terms of the subject matter, this is the most common quoted condition, which is that it must not exceed 1/3 of the property, and that's why I say that if they don't inherit under the wasiat, they can still inherit. That's why they inherit under faraid, because their portion is already affixed, and they do not need to be given a further portion under wasiat. And the next condition is that it must be something that can be inherited, it must be valued, and it can be something transferred after the testator's death and existing at the time of death. So you can't, perishables obviously is not something that you should include, or anything that we don't recognize the value of, for example, like najis or something like that, to give a very clear example. And it must be something that is permissible and is not subject to any prohibition. So obviously any matters like gambling, the proceeds of gambling, alcohol, these would not be something that you would be able to include in the wasiat. Okay, so this was the second schedule that I mentioned earlier. So this is the form that is included in the Selangor enactment. Of course, every state would be different, but it is usually more or less the same. And here I just wanted to give you an example of how it could be drafted. It shows here how all of the elements I mentioned earlier are encapsulated in this. So first of all, you mentioned that the testator is of sound mind, and he's able to appreciate the nature of the will. So he must understand that he's doing a will, and he must understand the consequences of the will. And then it includes the 1/3 aspect. so that it's only 1/3 of the properties being distributed. And it also includes options like infant, you can provide for your infants, and that you appoint an executor. So this is additional aspects which I provided here. So other aspects that most people like to include in the wasiat, though they don't form part of the main pillars, is that you appoint an executor or a guardian of your minor child. The wasiat also serves to identify assets, as the wasiat would list out all the assets and who to give it to. That's how you can identify which assets. It also includes assets which you can identify which once belonged to you, but you make a statement that it was given away as hibah. And this is what our firm practices and we encourage, because this avoids any doubt, and this also provides some clarity in case sometimes when you're giving properties or transferring properties, you don't inform your entire relatives or your entire lineage of your decision, right? So sometimes the only times they will be able to look at it is when it's written in written form in the wasiat, or it's supported by another document. So the content is the third is again to identify to complete the list of assets. And another aspect of a wasiat is that it remains revocable at any time during the testator's lifetime before he passes away. And this flexibility allows the testator to adapt his estate planning as circumstances change. And this is something that Mira will take you through on when you should consider amending it because of these amendments. Next, we go on to what is hibah. So hibah is literally a gift or bestowal, and it's the act of voluntarily granting ownership of an asset or property from one person to another when the settler is still alive without asking for anything in return. So hibah is encouraged in Islam, gifts, and it's based on this hadith on screen, which I won't read in full, but it's basically the encouragement of giving away something, and it's part of our Islamic values to share, to do good deeds and all that. So the pillars and conditions of hibah are similar to that of a there must be a grantor, the person who gives it. They must possess sound judgment, be of legal age, and also have full authority over the property being gifted. There's also a beneficiary. They must be capable of owning their property and the property itself, the gifted property. And there is also offer and acceptance in the sense that the act of giving and accepting the gift must be clearly pronounced, either verbally or through actions, to establish the transfer of ownership. So you must know that that this is being gifted to you and it's not something like on loan or being borrowed. So that's in terms of the pillars, they have similar pillars with the wasiat, but what distinguishes them is the timing limit and the revocability and recipient. So for the timing of a wasiat, it takes effect after death, so you can execute it anytime before your death, but the contents of the wasiat would only be affected after you pass away. So that's why the timing is different compared to hibah, which is considered a lifetime gift that is effective immediately. And there's a limit to the wasiat. As I mentioned earlier, it's limited to 1/3 of the estate unless all the legal heirs consent. And this is something that's done practically. And then for the hibah, there's no limit. You can give it to anyone. You can give it to your teacher, your friend, your neighbor. So there's no limit in terms of how much you want to give to the hibah and who to give it to. The revocability aspect, as I mentioned for the wasiat, it's revocable anytime after death, whereas a hibah, because the transfer is immediate, it is irrevocable once accepted and executed. It follows that it's irrevocable because once the transfer of ownership is already transferred to someone else, then the decision in respect of that property falls to that other person. So you can no longer say that it belongs to you, and you can no longer detect something that doesn't belong to you. From these key differences, I think a lot of people would say it's quite clear that they're different, wasiat and hibah, but why is there such a confusion? And the reason why we need to clarify that confusion is because in recent years, there's something what is called a conditional hibah. So I put it here in between hibah and wasiat from the previous table just to show you how conditional hibah is actually, it seems to be mixing the elements of both the hibah and wasiat, being a conditional hibah, being a gift with conditions. And the reason why it's mixed up with wasiat, because a lot of times, a lot of people are setting this condition to take effect upon death. And that is obviously not something that is desirable. So conditional hibah is to give specific aspects to chosen persons only after the occurrence of the condition. It's a bit technical in terms of having to explain it, but if I can get you guys to picture like why this conditional hibah term is being used, is actually because not all conditions will be dependent on death. So you can set a condition, for example, I want to give this to you, but I can only give it to you next month. So that's a condition that's determinable in a sense. Or for example, you're giving a gift to a child and you're saying like, if you get straight A's, I'll give it to you. So the condition is that they achieve something or that a certain time comes into effect. whereas that is possibly allowed, which we'll go into later. But if it's something upon death, then that's something that a wasiat should cover and not something that you should use a hibah for. The status of conditional hibah, like I mentioned, a hibah gift should ideally be given unconditionally because that's the purpose and that's the underlying value of why we support hibah. So when a hibah is a gift is accompanied by stipulations or conditions, it is classified as a conditional hibah, which is hibah. So Islamic jurists have different views on the legality of the conditional hibah, which can be summarized in either three of these categories, which is hibah, both the hibah and the condition is valid, or only the hibah is valid, but the condition is null and void, or both hibah and condition is invalid. So in Malaysia, how it is assessed is it's actually on a case-to-case basis. So the main examples that people often like to quote is the gift of a land from a parent to a child, where a parent says that you can live on this land only after I die. There's so many cases, and I see there's a lot of confusion because people don't really delve into or understand the reasoning or the assessments of the court. So the pattern that we've been seeing is actually conditional gift is something that is recognized. It's actually included in a lot of fatwas and a lot of religious scholars writing and all that. It's recognized in Malaysia and Islam, but what you need to go into in assessing whether it's acceptable or whether it's valid is you need to go into the hibah itself and the condition attached. So there have been several cases where the land is being gifted to a son or a daughter, for example, and there's cases where the Sharia courts have validated it and where Sharia courts have not validated it. And it goes into the root. We'll see that the Sharia court has assessed whether there has been any additional acts that come after the hibah. So for example, in terms of land, has the person who's gifting the hibah executed a trust deed? Has the person executing the hibah taken any steps to fill in any forms at the land office to show that this is that he's holding the property on trust now and he's no longer the owner of the property? So this is what courts will look into, and depending on what steps you've taken afterwards, that's where the court will assess whether a condition was valid or invalid. So it's not like a one-size-fits-all kind of answer. It's really case-to-case basis. But I hope this has clarified I know there's a lot of confusion in terms of conditional hibah, and whether the Sharia courts upheld it or invalidated it. So it's definitely a case-by-case basis. And if you understand the different instruments involved, you'll see why some instruments the court validated, some that the court didn't, because they looked at the overall estate planning. For example, I can give you a case where in assessing whether a land was validly given as a heap to, it was from like a Malaysian to another person who was unrelated to him, but the court saw that this person no longer lived on the land. He surrendered the title to the person who he bought the title to, and he also allowed that person to live for years and cultivate the land for 30 years. So the court found that this action of the gifter surrendering the title, accompanied by the actions of the person receiving the gift, it showed that they had every intention to treat it as an immediate transfer of property then and there, although they may have not taken the steps to register it at the land office. So that's where a conditional hibah was seen and was validated. And the condition there was the person said that you can have this property as long as you take care of the land. So they did fulfill that condition, and that's why the court upheld it. It would have been a different case if the person was giving the land and said that you can cultivate it for as long as I live, but once I die, then it's no longer yours. Then that's a conditional hibah, and the court may have different rulings if they had that scenario. Now the question becomes when and how to use a wasiat or hibah, or what should I use? Actually, there's really no right or wrong answer. It really depends on you, your assets, and what your main intentions are and what your priorities are. But where you can start is the process of preparing a wasiat or hibah actually is more or less the same. First of all, you identify your assets. Is there anything that can be transferred now? Is there anything that shouldn't be transferred now? And then you identify your beneficiaries. Is there anyone that you can trust now or later? And all of these aspects in deciding whether you prepare a wasiat or hibah. And we come into the picture if you're not sure, or if you have assets you're not unsure of, and we can advise you on the instruments that's relevant and related. But in terms of what to look out for when you're doing this process, Mira will take you through, and hopefully that'll be able to allow you to decide. But just to cover some common factors that people look at when to use a wasiat and when to use a hibah is, For a wasiat, it's when you have non-legal heirs. So if, for example, if you have an adopted child, as a Muslim, we recognize adopted children, but obviously they don't have any blood ties to us, which is basically one of the grounds for us to inherit through fara'id. In order to secure the adopted child to have something, because they won't get anything to fara'id if you don't do a wasiat, then you need to execute a wasiat so that you can provide for your adopted child. And also, if you have no children, you may want to give it to certain people, and you need to prepare for this, which Mira will cover better in more detail later. For wasiat, obviously, to appoint an executor or legal guardian is also recommended. We also have individuals who enter Islam and have no other Muslim relatives, so their non-Muslim relatives will not be able to inherit to fara'id. Executing a wasiat and giving them a portion would be recommended. You can also include express wishes for charitable donations or wakaf. And you can also make provisions for religious or personal guidance to family members, because at the time of your death, obviously upon probate process, the last thing that what they would look at is your wasiat, and this would be the last words that they hear from you. So it would be a good way to use the wasiat to remind the family of all your intentions and the values of as a family. And in terms of when to use a hibah, usually when you have specific assets that you want to be transferred to specific persons during your lifetime. So it's either to support a child, a spouse, or dependent, then you would obviously want to transfer during your lifetime and not wait upon your death. And this will provide security and stability, because obviously you can make provisions after your death through the wasiat, but you don't know how many people will honor your wishes. And nowadays, a lot of people are using wasiat to not follow the 1/3 rule. And as I mentioned, it needs the consent of all beneficiaries involved. During your lifetime, you can get everyone to agree that they will not contest your will, but upon your death, you never know, right? So if you have such real risks and you don't really trust people to respect your wishes, I know it's a harsh reality. So if you have those sort of concerns, then obviously you would want to utilize a hibah rather than wasiat. And another reason why people utilize hibah is because it avoids estate delays. Because, for example, if you want to transfer land during your lifetime, then the conveyancing would take effect immediately, and you would have control over that conveyance, and you can monitor it, and you can monitor that it's been affected during your lifetime. Whereas if anything is supposed to happen, any conveyance of property after your death, obviously it now falls to the executor, or if you don't have a wasiat, it would fall to your administrator, and they may take time, and then even then it takes a certain process. They have to go to court before they go to land. But if you do it during your lifetime, you can skip this court process, the probate process, and go straight to the land office and effect the transfer as you intended. And another reason to use hibah is you can assess your distribution as it is today, who survives you now, parents, spouse, children, and we can calculate as well for you on who will be the intended beneficiaries in the event you don't have a wasiat and it's just fully fara'id 100%. And you may be surprised at the fixed portions, and you may not agree with it. And so if you want to make sure that the person that you want to have the most gets more, then you need to make that provision during your lifetime and not wait. So the third point is actually for people who may not have male heirs, there's the Baitul Mal, which stands to inherit a portion of your property. A lot of people don't want that because there's a lot of uncertainty there, and there's also another procedure. Not only do you have to go to the court, the land office, you have to treat the Baitul Mal as another beneficiary, and you have to get their agreement. And they will also assess whether they want to waive some of their rights under fara'id or not. So that's also another procedure. And a lot of people who have, when they calculate and they end up seeing that Baitul Mal stands to inherit a portion, that's where they opt to use hibah to make sure that they transfer everything before the lifetime and not wait till death. So that covers my portion, and I pass it on to Mira to take you guys through the planning for non-Muslims and all the other scenarios that can occur.
Good afternoon, everyone. Thank you, Anis, for introducing me. My name is Mira, and I will be continuing with the second part of this talk. Whilst Anis has gone over the fundamental concept of what is wasiat, what is hibah, what is the type of hibah, so I'll be going on to the second part, which we will be more discussing on when we can use it, especially in this modern day and age. So allow me to start with the first top point, which is planning for non-Muslim relatives, blended families, adopted children, or foreign assets. Okay, now before we delve in, let's recognize how modern families these days have evolved. So previously, the family structure was pretty much predictable. You have a mother, a father, you have children, all are Muslims, and all are living in the same country. So in this situation, estate planning is pretty much very straightforward and fire aid can apply with minimal complications. However, the reality today for modern families is different. So one of the things that we see nowadays is that there is also involvement of stepchildren or adopted children. So these children may be those that you raise that are financially dependent on you. And whilst in some situations may be biologically related to you, but most of the often they are not. So in this situation, they would not be considered legal heirs. So like Anis mentioned just now, a legal heir is those individuals that are recognized under fire aid are entitled to receive under Islamic inheritance laws. So for that, there is for stepchildren or adopted children. Second is for non-Muslim relatives or non-Muslim children from a previous civil marriage. So let's say if you have, but you still have parents, siblings, or maybe children that you had from a previous civil marriage that are non-Muslim. So this group of people will not be considered eligible to be entitled to inherit under Islamic inheritance laws. Another one is blended families from remarriage. So this correlates with the first 2 points that I mentioned just now. So if you remarry and then your spouse has children from a previous marriage, so these children will not be entitled to inherit from your estate because they are not considered legal heirs. There is also the aspect of owning assets or properties in foreign jurisdictions. So let's say you own a house in the UK or you own land in Singapore or any other assets that are in foreign jurisdictions. So obviously Malaysian law and Islamic law per se be used. There are some countries that do not even recognize Islamic inheritance concepts. So for this, it may lead to delays in distribution. Your assets may also be distributed not according to your intentions. So, knowing this situation, Wasiat and Hibah assist you. So, for those families that have stepchildren, adopted children, or relatives or children from previous marriage that are non-Muslim, how Wasiat and Hibah can assist you in these situations. So, for instance, if you intend to allocate a certain asset, or if you wish to allocate 1/3 of a portion of your estate to certain beneficiaries, such as stepchildren, adopted children, and your relatives, you can allocate this in your Wasiat. Let's say if you have a specific house, a car that you wish to give us to a specific beneficiary, this can also be provided into your Wasiat. Alternatively, you can also give Hibah, you can give to a specific beneficiary also during your lifetime. So if you wish to give your house to your daughter whilst you're still alive, you can gift it to her using Hibah. So this allows you greater control over your assets and who receives your assets, while ensuring that there is minimal disputes from other parties. So by using Wasiat and Hibah, you ensure that your loved one, regardless of who they are and regardless of religion, will receive financial protection and allowed to be taken care of. So this, like I mentioned just now, blended families is also the same. You can use a Wasiat to express your intentions and ensure that no dependent is overlooked. You can also use Hibah to allow control and immediate transfer to chosen family members. Now, although I said you can use Hibah, what I mean is that I don't mean that you can use one or the other. You can use both if you prefer. So if let's say in a particular situation that you wish to transfer your house to your daughter currently, when you're still alive, you can do that. But let's say after you choose to still allocate 1/3 of your portion to another family member or maybe your stepdaughter or adopted child after you have already passed away, you can also do that using Wasiat. It's not one or the other concept. Also, for the concept of owning assets or properties in foreign jurisdictions, how a Wasiat can assist you with is that your local Wasiat a Wasiat that is drafted locally in Malaysia, you can state out what are your assets in Malaysia. And in there, you can also state any foreign wills that you have drafted in a foreign jurisdiction, so that after you have passed, your beneficiaries, your executor can take note there is another foreign will that they should take note of, and then to distribute accordingly to your intentions. So now let's move to avoiding common pitfalls. So we usually hear that nowadays, my family knows what are my intentions, I'm sure it will be fine. But more often, this is where things go wrong. So let's go over what are the common pitfalls that we usually see in our practice and how it may affect your estate planning if it is not addressed accordingly. So first of all is insufficient planning. There are some that assume that Fara Aid would automatically handle everything, but there are certain aspects that Fara Aid may not address specifically, like Anis mentioned just now. So there are things such as it does not address distribution to non-legal heirs, such as your stepchildren, non-Muslim relatives. It does not address for, let's say you have a minor child and who do you wish to appoint as your guardian. Maybe how you wish for your debts or your funeral expenses to be distributed or handled accordingly. Or maybe there are some properties that you wish to wakaf or to certain institutions or charities. So this is not addressed specifically under Fara Aid. So without a wasiat or hibah, legal heirs may face delays, disputes, or unintended outcome. Now, the second aspect is confusing wasiat and hibah. So there are those that don't really understand what is the difference between the two, I would say, procedures and documents. So they mistake the concept of one or the other, which may cause gifts to be invalid or cause estate complications. So for example, if a person intends to hibah the house to their daughter, but they did not execute the formal documents. So this may cause that the house will still be under the estate and later on be distributed according to Fara Aid, which obviously does not reflect your intentions. So when we talk about distribution, it also involves family. So not only is it a legal matter, but it is also an emotional matter. So there are certain situations when we talk about unequal distribution without explanation. We have seen that maybe parents allocate or distribute more property or more assets to one sibling more compared to the other. So obviously in these situations they would have the reason why. Is it maybe they have taken care of the parents while they were old, or maybe one sibling will need it more than the other. This will obviously have the reasons, but without a proper explanation, this may lead to disputes among the siblings after the parents have already passed. So having a valid reason and recording it in proper documentation can obviously resolve any future disputes. Second of all, we have exclusion of vulnerable members. So as explained just now, there are family members such as adopted children, non-Muslim children, or relatives or stepchildren are excluded under Fara Aid. So without a wasiat or hibah in place, they will not be entitled to your estate entirely. Thirdly, we have also relying on verbal promises. Now, wasiat can be made orally. However, we would usually advise our client to have a written wasiat to ensure that your intention is documented, signed, and witnessed. So there's situations where we hear that a sibling would say, oh no, my dad has promised me this, that the house will go to me after he has passed away. But then another sibling has said, no, but dad has promised that this house will go to me after he passed away. So by having a wasiat and a formal documentation, your instructions, your intentions can all be formalized and everyone can refer to it in the future. Now, besides this, there is legal and administrative pitfalls. So maybe your intentions are noble, but maybe the execution is where all goes wrong. So first of all, there is poorly drafted documents. So there are some documents that may be incomplete, vague, or have inconsistent instructions, which may cause the wasiat or hibah to be contested or rejected. So for example, in your wasiat, if let's say you drafted saying that, oh, I wish to give this asset to my son. So then there is the ambiguity if let's say which asset you wish to give. And if you have more than one sons, which son do you wish to give that asset to? So this ambiguity will cause trouble in the future. And if let's say the dispute goes to court, there are certain situations that court will have to disregard your wasiat and maybe go to Fara Aid instead. Secondly, there is no witnesses or invalid execution. So there's some that would think, okay, I have drafted already my wasiat, so that's all complete and done. But no, let's say if the wasiat is not signed properly or witnessed properly, it can void the will. Thirdly, there is a failure to amend or update wasiat. So one thing we would always advise and remind our clients is that to regularly revisit your wasiat and update if there is any major changes in your life. So life changes such as remarriage, birth, divorce, asset sales will require updated documents. Okay, so knowing all of these problems, how can we avoid these pitfalls? So first of all, always start planning early. It is best to start your estate planning when you are young, when you can think properly, and so don't wait until you are old or you are already succumbed by illness. Plan when you are mentally and legally competent. Second, understand and use the correct document. So know what is the difference between Fire Aid, Wasiat, and Hibah, and how actually these three procedures can actually complement each other to achieve your intended estate planning. Thirdly, how to appoint a legal advisor. Use qualified professionals to assist you in drafting your documents. So, a legal advisor will assist you in drafting your documents so that it can achieve your intentions on what you intend for your estate planning to do. So, not only will they advise you on the drafting, but what are the procedures after you have already executed your wasiat. Now, fourth of all, communicate with your family and appointed executor. So this is not compulsory, but we would generally advise for you to communicate with your family and appointed executor to let them know of your intentions, so that later on, after you pass away, they are not surprised, and maybe to prevent any disputes later on. And lastly, to review your wasiat regularly. So like I mentioned just now, revisit your estate plan every 2 or 3 years after major life changes. So let's say if you have intended to give a house to a certain beneficiary, what happens if, let's say, the beneficiary has passed away before you do? In this situation, it is advisable to either provide for a substitute beneficiary, or maybe to just reamend and give it to another person. Let's say if you have remarried or if you have acquired new property. So all of these aspects will have to be included in your wasiat so that you can update your current circumstances so there's no surprises after you have passed away. So I believe that's my slides for today. So now we will proceed with the questions. Over to you, Zoe.
Thank you, Anne. Thank you, Mira. Thank you, Annie, for sharing your valuable insights on the options under Shariah estate planning. We will now address questions from the participants in the Q&A chat box. I see we have a few questions. First questions we have is, what is the proper mechanism for a business owner to retain control of their shares until death and then transfer them via Hibah after death? Can I pass these questions to Mira?
Yes, hi Zoe. Okay, let me just reread the question. What is the proper mechanism for a business owner to retain control of their shares until death, then transfer them via Hibah after death? So you do not want the distribution to fall under Fara 8. Okay, so for this question, I believe because there is an overlap of not only Shariah matters, but it's also corporate matters also. So I think for this question, we will have to obtain more information before we can have an exact answer, before we can provide you with an exact answer. But one of the things that we definitely will have to review first is if your company constitution has already catered for succession. So after we've reviewed that, we can advise you accordingly. So after this, please reach out to us so we can know more about your inquiry and can advise you more. Okay, thank you, Zoe.
Thank you. So the next question is, in the case of Takaful insurance nominees, are they treated merely as executors for distributions under Faria? Can Hibah principal override this? Can I pass these questions to Anis to answer this?
Sure, Zoe. Okay, this is, I think, quite a controversial question recently. I think a lot of people were asking me about the recent Hibah, the viral Hibah case. But it actually really depends on the insurance policy and the underlying contracts used by your insurers, because it can be merely as executors, but if they utilize the correct contract, and it's usually in the written agreements where it's expressly stated that it's Hibah, and then the funds provided, like the premium provided, is kept separate, usually in an account, and it's basically the insurers have done something in the back end to make sure that the property is already been transferred, then that could be seen as a Hibah rather than them coming in and as an executor. I wouldn't say that Hibah principles overrides, but you must look at the underlying contracts of each of these, because even insurance policies, they're a mix of everything. Like my own, I have both the Hibah element, I also have a other aspect. So I also struggle to understand the differences as well. But yeah, I'm not in a position to definitely say what that sort of setup is, because I've realized that a lot of insurance policies, the underlying contract is quite different, although they can be similar, but how they promote it and how they actually execute it in the back end is quite different. So depending on that, it depends actually, yeah.
All right, Anis. Another question for you is, in practice, does a Hibah require immediate transfer of ownership, or can the transfer be deferred until after the donor's death if they wish to retain control during their lifetime?
Okay, so yes, the quick answer would be yes. This is the position that our firm takes. It is immediate transfer and it can be deferred, but it should be the reason for deferment is not death. It must be something other. So like previously I mentioned, it could be the condition that it happens next month. So a specific date. It could happen on 20th of June. So I will give this gift to you on 20th of June. So it's determinable and it's not something that's unsure, which is my death. I can't say it shouldn't be that I give this to you only upon my death, because that's a deferment that's uncertain. But if the deferment is something that is quite, you can determine what it is, you can see what it is, and it's reachable, then it can be deferred. But in terms of estate planning, we always make it as a best practice for our clients to understand that we want this to be immediately transferred, and we would always advise for them to execute further documents to support this. But if your concern is retaining control during your lifetime, what we would advise is still immediate transfer, but to ensure that you maintain control, you use other instruments to retain your ownership. So that's where the trustee comes in, the power of attorney comes in. So although it's registered in someone else's name, in the document itself, it would state that the person who retains control or whoever the trustee gets instructions from is you. So that is how you retain control, but immediate transfer is effected. So that is how we would address this sort of scenario. I hope that clarifies a few things.
Okay, I see we still have a couple of minutes left, so I will pick last questions. So from Mr. Hamlin, he did ask the questions: can illegitimate children inherit? And is reasons why one can get more than another in wasiat compulsory? Mira, do you want to answer these questions?
Yep, thank you, Zoe. So for the first question, wait, let me read that question again. Can illegitimate children inherit? The illegitimate children can inherit from the mother's side, but cannot inherit from the father's side. So yeah, that's the first question. And is there a reason why one gets more than the other? Wasiat compulsory? I believe your question is asking, is it compulsory that one gets more than the other in a wasiat? If that is your intention, no, it's not. Your wasiat is up to you on how and who you wish to allocate certain assets in your estate to, as long as it complies with the one third portion. Yeah. Thank you, Zoe.
Thank you again for Annie for the talk today. Now, before we conclude today's sessions, I have a few announcements to make on behalf of the firms. Let me share the screen. First, please do join us again for our upcoming talk regarding cryptocurrencies and anti-money laundering risk trends in Malaysia on 25th of June 2025. Secondly, as always, we have a feedback form for today's sessions. So please do let us know what you thought about this talk. The link to the form will be posted in the chat. Thirdly, you can also follow us on our social media accounts. We are on YouTube, Twitter, Instagram, LinkedIn, and Facebook as well. Fourthly, if you would like to speak with any of our lawyers, we offer a complimentary consultation of up to 30 minutes over the phone or over video conference. To do, please fill in the forms on our website. The link also is posted in the chat box as well. That is all for today's talk. Thank you very much to all of our guests for joining us. As always, we hope you found today's sessions informative and useful. Thank you again and see you at our next talk.